I still have my voice with me that I brought from Peru. I spent 2 weeks in Lima attending the Montpellier Society conference and the Libet Fund. And I was told by the Danish cartoonist, because he was one of the speakers at the conference, to send his warmest regards. And he's actually tried to invite himself to Australia, said if there is anyone interested in his presence in Australia, he would really like to come. And he is the person involved in the debate that triggered all those retaliations. And he's surrounded by security guards, and he lost completely his freedom. But his book is called The Tyranny of Silence, which is a very good book, and I highly recommend the book. So I think I would try to say something that will be a little bit different. I have written papers on the unconstitutionality of religious vilification laws. That's not exactly what I'm going to be addressing in this event. And also another article that I think it's important on Section 18C. But what I'm going to say today, I will try to do something different, is to explain the postmodern underpinnings of vilification law and how it can be used or can serve religious intolerance rather than just, the idea is that it will protect people from bigotry, but the bigots themselves can use this kind of laws. And so the idea was that we would all be protected from bigotry, but the bigots are those who can easily hijack this kind of legislation and use that for the purposes of persecuting people. I will start with John Locke. I know that I'll probably be booed now because when Jim Allen said that he was not a natural lawyer, he was applauded. I actually believe in natural law. And I'm going to talk about John Locke a little bit. John Locke is called the father of classical liberalism because of his great contributions in political philosophy. And among other things, he is also the kind of spiritual father of the American Declaration of Independence. And yet, it's curious to note that Locke's defense of religious freedom, which is in line with what most of the greatest thinkers in classical tradition thought, actually believed, was not grounded on a doubt about truth or any sympathy to the beliefs that he thought should be tolerated. Instead, Locke argued that many opinions he proposed to tolerate were actually false and absurd, according to his own words, at least according to his own opinion. He was adamant that since there is a God, according to him, humans are obliged to observe his moral laws with, and then I quote from Locke again, utmost care, application, and diligence in seeking out and performing them, insisting, once again quoting from Locke, that there is only one way to heaven. That's Locke saying that, according to him, there is only one way to heaven. Still, Locke also contended that everyone is individually responsible for finding, and I quote from Locke, the narrow way and the straight gate that leads to heaven. In essence, Locke believed that since man cannot be forced to be saved, religious truth must be left to individual conscience and individual discernment. That nobody can be regarded as a free citizen without freedom of speech and freedom of conscience is the very essence of the classical liberal defense of religious tolerance. But given the moral relativism of our time, regrettably, this traditional concept of religious tolerance is gradually becoming obsolete, being replaced by a new approach that denies the possibility of truth, proclaiming the moral equivalence between all religions. Western societies have now moved away from the free exercise of religious expressions, choosing rather to impose the unreasonable assumption that all beliefs are equal in value and deserve our equal respect. But once we slide from the classical conception of tolerance to this postmodern, morally relativistic postulate, Intolerance ceases to represent a rational rejection of particular ideas, and instead morphs into a censor of all questions and statements that contradict the general assumption that all opinions, all religious beliefs are equally valid. As such, to question the assumption that some religions are actually better than others becomes, by its very definition, the ultimate act of intolerance and must therefore be condemned. Hence, the classical link between tolerance and judgment is lost due to a refusal to pass any valid judgment, creating a position that conceives tolerance merely as the superficial signifier of acceptance and affirmation of anyone and everyone. Although the previous federal government, the Labour government, considered in 2012 extending its anti-discrimination laws to include a protection against offenses or insults to religion, fortunately, Australia still remains devoid of a federal legislation that specifically establishes the crime of religious vilification. The proposed legislation adopted that would be introduced adopted a concept of religious discrimination that criminalized conduct that offends, insults, or intimidates another person on religious grounds. Since there is no element of objectivity in the words reasonably likely to offend, people would become culpable for discrimination even if they were telling the truth, thus making the truth of statement irrelevant for the purpose of identifying discrimination. The anti-discrimination draft bill apparently sought to consolidate the existing Commonwealth anti-discrimination laws into a single act. However, in reality, it would have gone much further than simply consolidating such laws. The proposed legislation would expand the concept of anti-discrimination laws while simultaneously imposing significant restrictions of freedom of speech and freedom of religion, including at the workplace. The good news is that thanks to the widespread community outcry, the federal government shelved that draft bill. However, it's a fact that 3 Australian states have introduced state laws designed to prohibit religious vilification, namely Queensland, Tasmania, and Victoria. The government in South Australia, by the way, proposed to amend its racial anti-discrimination laws to include religious vilification, but the proposal was rejected after the public objected. Similarly, in Western Australia, the then Labour government dropped the idea once it realized that it was too hard to devise laws that could be fair and workable. In Tasmania, on the other hand, Section 19 of the Anti-Discrimination Act, 1998, determines that no one can publicly act in a way that incites hatred towards serious contempt for or severe ridicule of a person or persons on the basis of their religious beliefs or affiliations. In Queensland, the Anti-Discrimination Amendment Act 2001 mandates that a person must not publicly act in a way that would incite hatred towards, serious contempt for, or severe ridicule. This provision dealing with serious religious vilification is actually comparable to the Victorian legislation. In New South Wales, a proposed amendment to the Anti-Discrimination Act 1977 would have added the term ethno-religious to the definition of race. Fortunately, this bill was decisively voted down in Parliament on the 1st of March 2006. And as you know, Bob Carr, the then Labour Premier, considered this idea of religious vilification as deeply regrettable, that was the terms that he used, and highly counterproductive. And one thing that's quite interesting is that to perhaps reinforce his claim, he referred to a number of cases in Victoria. For example, the case of this Satanist incarcerated in Victoria for abducting a teenager girl and using the girl as a sexual slave. And he made a complaint under the Victorian Racial and Religious Tolerance Act after attending a Salvation Army course held in prison. He argued that the Salvation Army posed a danger to his safety for running a course that discriminated against him and his master on the basis of his, and discriminated him in the basis of his religious belief. Judge Morris dismissed the case as frivolous, but warned of the need for the legislation to be amended to prevent preposterous litigation. In determining whether a person has vilified another, the vilification law in Victoria states that the person's motive to engaging in any such conduct is actually irrelevant. In other words, the motivation of the accused is considered not important for the purpose of the legislation. By declaring the relevance of truth and motivation, a person may actually be condemned for inciting hatred, even though he or she actually had no intention to do so, unless the accused falls within exceptions of good faith, art, academic, science, or public interest. These exceptions create a two-tiered system of speech by which only the learned, the intellectuals, can freely express their ideas, but the so-called irrational masses are restrained for doing so, which creates a kind of an elitist approach that you are allowed to speak provided that you belong to the category of the learned ones or the betters. So, whereas the truth, rightly so, has always been a primary element of defense in defamation cases, the advent of a postmodern philosophy, which postulates that truth is socially constructed, has introduced the belief that truth is invariably relative. But if truth is always relative, then what happens? Well, one might conclude, and Stanley Fischer, who is one of the leading postmodernists, actually reached this conclusion, that there is no such thing as free speech, which validates the criticism of a person's beliefs and values. After all, if everything is relative, who are we to criticize someone's different ideas? This perhaps explains why vilification laws often hold the premise that the truth of a statement cannot be relied as a defense. Such a law is elaborated by people who are deeply skeptical of objective truth, religious or otherwise. Perhaps this might explain why religious vilification laws do not seem to take religious claims seriously. Under postmodern theory, of course, what one takes as the truth is no more than a Christian perspective, it could be a Jewish perspective, a Muslim perspective, and so forth. Each of them are correct in terms of their own religious context, so that truth can be readily dismissed as something to be regarded as being naive at best and deceptive at worst. In the latter situation, an attempt by a group to impose its own perspective on all the others. And yet, as law professor Carl Esbeck from the United States reminds us, one who has never disagreed with others about religion is not commendably tolerant. No, he's not. But is treating religious difference as trivial, as if religious beliefs actually do not matter. That is just a soft form of religious bigotry. Naturally, the more radical branch, of atheism, these people, the radical atheists, don't believe that religious belief ultimately matters. Curiously, most of the most important postmodern thinkers happen to be atheists. That's the case of Foucault, that's the case of Derrida, and I could enlist many of others who would fall into this category. They would insist that religion is politically divisive because allegedly religious people believe in ideas of absolute truth that are intolerant to different opinions pertaining to the other truths. Of course, the assumption is mistaken because as John Locke and others previously, especially coming from the classical liberal tradition, demonstrated, one may express quite strong convictions about the reality of existing things and still remain tolerant towards what they regard as being erroneous opinions. However, the idea of imposing by law the limitation of religious convictions to merely private preference has been filtered down from the postmodern academic elite to our unenlightened legislators, who now think that they can silence robust religious discussions on grounds of preserving tolerance. These unenlightened legislators have therefore embraced the postmodernist fallacy of denying objective truth and meaning, for they see any claim to the truth simply in terms of personal preferences. And now that's the general underpinning, of the vilification laws. But now you're going to see a surprising outcome, which is that the fact that the law can be hijacked by absolutists and religious fanatics. Although religious vilification laws are undeniably postmodernist in their philosophical nature, ironically, religious extremists can actually hijack these laws quite easily to secure immunity for their beliefs from public scrutiny. Indeed, anti-vilification laws, in essence, appear to serve the purpose of establishing a sort of blasphemy law by stealth, could be Sharia law by stealth, a suspicion that is reinforced since the strong insistence of the powerful Islamic Council of Victoria resulted in the enactment of the Victoria legislation. While the majority of Muslims living in this country are law-abiding citizens, following a non-literalist version of their religion, there is now a widespread perception, so I don't want to lose my voice, that many Western Muslims believe that blasphemers actually deserve some form of punishment. Across the Muslim world, as you know, accusations of insulting the Islamic faith are systematically dealt by means of death threats, imprisonment, beatings, and the death penalty. In these countries, religious persecution is reported in 100% of the cases. Indeed, religious persecution not only is more prevalent in Muslim-majority countries, but it also generally occurs at a more severe level. Of course, religious extremists living in Western democracies would have to find different ways to use the legal system if they want to punish people who offend their beliefs. Regrettably, they will find in these religious vilification laws a suitable mechanism to strike fear in the hearts of the so-called enemies of the faith. Indeed, one of the greatest ironies of religious vilification laws is that their chief beneficiaries are a small but vocal group of religious bigots. Although it's not clear why such bigots should deserve any merit, to receive statutory protection from severe criticism, surely the contrary is required. Surely some of the beliefs are deeply disturbing. For example, a Muslim cleric from Melbourne has notoriously declared that male Muslims should have the right to hit and force sex upon their disobedient wives. Although such a sexist remark deserves our strongest possible criticism and condemnation, even the slightest criticism of some statement by these clerics may result in an individual being dragged into a secular court and charged of being offensive or committing vilification. Well, then I'm going to just put this in a way that's like very basic, but I have written about more comprehensively why I believe these laws are unconstitutional. And I teach constitutional law, by the way. Together, I have two topics, legal theory and constitutional law. So I try to combine both in this paper of my areas of expertise. Whereas the Australian Constitution does not contain a comprehensive declaration of human rights, the High Court has found it to contain a few implied rights. Amongst these implied rights is the right to freedom of political communication, which the court declared to protect insults, abuse, and ridicule. The court deemed these means of communication as legitimate parts of political discussion. Religion is rarely and simply a private and personal matter alone. Rather, the very nature of religious speech is often intertwine with political opinions, perspectives, philosophies, and practices. As such, religiously inspired speech must be constitutionally protected if they are sufficiently connected with the matter of politics, so that law which prohibits religious vilification will infringe the right to freedom of political communication. In this sense, Australians are constitutionally entitled to criticize strongly and ultimately reject any religious belief. They have the right to openly manifest their opinion as to why they might regard any aspect whatsoever of a particular religious belief as ultimately mendacious, retrograde, and mindless. Otherwise, are we really willing to create in this country the same crime of blasphemy that the organization of the Islamic Conference demanded when it passed the United Nations a motion that prohibits defaming religion and imposing strict limits on freedom of expression in the religious domain? Just to conclude, in an environment where radicalized Australians have not only expressed sympathy with Islamic terrorists, but also became some of them terrorists themselves, religious vilification laws have the deleterious effect of making citizens unprepared to criticize or even give warnings about the nature of certain religious motivations or beliefs, however well-based these concerns might be. This is the singular tragedy of these so-called multicultural societies, which engender postmodern philosophy into legislation that reduces free speech on some of the most fundamental issues of public morality. Of course, there is no apparent reason why religious speech, which is motivated by political concerns, should not be characterized simultaneously as political communication for the purpose of receiving proper constitutional protection as a basic right of every Australian citizen derived from the freedom of political communication, a freedom which is implied in an Australian constitution. Thank you very much.